I want to talk to you today about euthanasia. Euthanasia is a Greek word that literally means a happy death or a good death. Uh, Let me give you the general definition of euthanasia, and then I'll explain the different forms of euthanasia that we're dealing with legally now, and what the moral issues of each one of those are. Euthanasia has a very simple definition. This is the definition. Painlessly putting to death someone suffering from either a terminal disease or terminal condition. Let me repeat that for you real quickly. Euthanasia is defined as painlessly putting to death someone who is suffering from either a terminal disease or a terminal condition. Painlessly is key to the act of euthanasia. We need to realize that someone is putting someone to death who is suffering either from a terminal disease or a terminal condition. A terminal disease, for example, is stage 4 cancer. Many stage 4 cancers, there's very little hope of remission or curing it. It's almost a death sentence. It can happen at any age, at any time in life, and it's almost always irreversible. Terminal condition is where you, let's say, become paralyzed as a result of an accident, perhaps paraplegic, where either your lower limbs or your upper limbs are paralyzed, or quadriplegic, where both the upper and the lower limbs are paralyzed. That is an irreversible condition. As of now, we don't have a way to regenerate those nerves. There are spontaneous remissions. Some might say that there are miracles. We don't want to argue against that. But by and large, those are terminal conditions. We do not know yet how to reverse those factors. So again, euthanasia is defined as painlessly putting to death someone who is suffering from either a terminal disease or a terminal condition. That definition has been in place since the ancient Greeks back in the Hippocratic Oath, as well as recently up until 1990, and I'll give you another podcast explaining the Supreme Court law that changes the nature of euthanasia and how we approach it. Now, euthanasia, for the most part, has always been an act of commission. In other words, someone is committing an act, painlessly putting to death. Someone is committing an act. What is that act? Putting to death. And that act, therefore, is considered a premeditated murder because someone is painlessly, intentionally putting someone else to death, albeit they're suffering from a terminal disease or a terminal condition. Now, in 1990, a Supreme Court law was passed called Cruzan versus Missouri Health Services. In this case, there's a young lady named Cruzan in a car accident, and she becomes she finds herself placed in a permanent vegetative state. She suffered brain damage. She's not brain dead. There's no hope of recovery. Her father petitions the court of Missouri to pull the plug, and they say no, they can't do that. And that's because the state has a vested interest in always preserving life. Don't forget the Declaration of Independence gives us right to life, liberty, and the pursuit of happiness. If you take away someone's liberty, their freedom to make this choice, and someone else decides to pull the plug, then you take away their life, and obviously there's no pursuit of happiness anymore. So the state is invested in protecting the promises that are encoded in our Declaration of Independence, the promises of life, liberty, and the pursuit of happiness. However, in 1990, the court also said that there are situations, circumstances in which a patient who ultimately finds himself in a persistent vegetative state or a deep coma, irreversible coma, might have previously given someone knowledge of what their personal will would be. Perhaps they didn't want to live like that for the rest of their lives. And so in 1990, in this Supreme Court case, Cruzan versus Missouri Health Services, the court recognized that we could have a living will, a document that was written previous to entering into a vegetative state, a persistent vegetative state or a persistent coma, where the patient declared in a legal document, a living will, what their medical desires would be. Perhaps they didn't want to live out the rest of their life that way, and they wanted the plug to be pulled. And the court said, if we have evidence of the person's will, don't forget we have life, liberty, we have freedom. If they freely choose under those circumstances not to want any more medical assistance, to have all medical assistance withdrawn, the court would honor that because that's the will of the patient. we have free will, and the court wanted to honor that, but it needed verifiable evidence that this, in fact, was not just hearsay. Someone said they heard it, someone else said they didn't, but this is a legal document that confirms the will of the person. It's called a living will. So in 1990, Cruzan versus Missouri Health Services gives rise to living wills. It also gives rise to powers of attorney, people who could act on your behalf, both financially and medically. It also gives rise to surrogates, people who can act in your place. You designate them as your choices to make final end-of-life decisions if those are necessary, if you find yourself in that kind of a medical situation. What it does then, what Cruzan versus Missouri does, is it establishes the patient's right to voice their will when they're no longer capable of doing that. Now, since that case then, our definition of euthanasia had to be altered. We don't want to change the fact that when someone intentionally puts someone to death, even though they're suffering from a terminal disease or condition, we don't want to say that's not murder. That's still murder. So that is now called active euthanasia. Someone acts in an intentional way to terminate the life of another human being. That's premeditated murder, and we don't want to mess with that part of the law. However, if a patient has a living will or some legal document that establishes clearly what they want and don't want done to them in certain end-of-life situations, the court is willing to honor that. Therefore, we now call that kind of euthanasia passive euthanasia, because what's happening is treatment is being omitted at the patient's request. Treatment is omitted and nature is allowed to take its course, even if that results in the natural death of the patient. In other words, if you say, I don't want any chemotherapy, I don't want any drug therapy, I don't want any radiation, I don't want any surgery, I'm a stage 4 cancer, just let me go. The court will allow that as long as it's enshrouded in a legal document, someone of sound mind. The court will honor that. We then alter the definition of euthanasia, not to change active euthanasia, this is still murder, but to allow for passive euthanasia. We omit treatment and we allow nature to take its course. In this case, death is the culprit. The medical community is not liable. They cannot be sued because they're honoring the will of the patient. It's very important we understand the distinction, because passive euthanasia is now part of the legal process in which we decide end-of-life issues or terminal condition issues or terminal disease issues. This is all legal. Ethics will always equal the law when it comes to what you're allowed to do and what you're not allowed to do. And so the fact now that we can present living wills to the court is a very important factor when it comes to your health decisions and your end-of-life decisions as well.